Bloomberg Audio Studios. Podcasts, radio, news.
Right now, in one federal courthouse in D.C., two of the world's biggest tech companies are facing a reckoning. On the second floor, Meta, the company behind Facebook, Instagram, and WhatsApp, is up against monopoly charges filed by the Federal Trade Commission. And 2 floors up is Google, which recently lost 2 antitrust cases and is now awaiting a judgment that could lead to a breakup of the company. Both cases are part of the U.S. government's growing antitrust enforcement push that's been putting increasing pressure on big tech.
It's kind of stunning that this is the one issue, this anti-tech sentiment. We know they're powerful. We need to do something about it. That is like the most bipartisan topic now and in the past 10 years, I want to say.
That's Sara Frier, a Bloomberg technology editor who's been following these cases.
This has really driven a strange thread of collaboration between Republicans and Democrats over the years, from the first Trump administration to the Biden administration, and now in the second Trump administration, trying to tie it all up with a bow.
Today on the show, big tech is on trial. How the monopoly claims against Google and Meta could reshape the industry and the way we use the internet for decades to come. I'm Sarah Holder, and this is The Big Take from Bloomberg News. I am thrilled to be sitting down with 2 of Bloomberg's eminent Saras. We have Sara Frier. She's a technology editor for Bloomberg and the author of No Filter, The Inside Story of Instagram. Welcome, Sara.
Thanks for having me.
And Sara Forden, our second Sara or our third, depending on how you're counting. She oversees legal news at Bloomberg, and she's been covering Google and its court battles since 2010. Thank you for being here.
Thank you for having me.
Sara Frier, you've been on the tech beat for a while, and you've traced how big tech companies have been under increasing scrutiny in recent years, including in the antitrust space. What led us to this moment? Why are Google and Meta in court facing monopoly lawsuits at roughly the same time?
I think it's a combination of a few really important things. The government has gotten a lot smarter about the level of power that these companies have and how they're wielding it. A lot of the first awakening of these companies and what they've done was centered around the consumer experience. It was stuff around privacy, content moderation. Did they let Russia manipulate the 2016 presidential election? But these antitrust trials, over the years, the government's gotten really smart about exactly what makes these companies tick. For Meta, the trial centers around how Mark Zuckerberg built his empire, literally the secret sauce of why his company got so big and powerful. The Google trial is centered around search, their power in search, and what they can do to remedy what they've now declared to be an illegal monopoly power, as well as ad tech, which is how they make most of their revenues.
Just to take a step back and follow on what Sara Frier said, another reason it took a long time to get here was that these companies are primarily offering free services. And typically antitrust law had looked at price and are things getting more expensive for consumers. So they had to really revisit how they're looking at these companies. And so what you have now are 2 behemoth tech platforms. They're making gazillions of dollars every year on people's data and information. And so that sort of became the new currency in these cases. And the government antitrust enforcers have taken a long time to study these markets. So both the search market and how advertising works in search, and the social networking market. And so it represents a longer term building of appreciating how big and powerful these companies came and how unfettered they were.
Sara Forden, I want to take a closer look at the Google trial. Judges have already ruled in 2 separate cases that Google is a monopoly. One case involves Google Search. The other is tied to the company's ad technology, as you mentioned. We're now in the remedy stage of the first trial, the one that involved Google's search monopoly. So what are the proposed remedies here?
Yeah, so that trial is now in its final week. The judge has been hearing arguments from both sides, and the DOJ wants Google to sell off its Chrome browser. That is probably the most dramatic remedy proposal. And while Google argues that has nothing to do with the harms, in this case and the monopoly over search, the government says that the browser is really the gateway to the internet, and so that's vital for that to be opened up to competition. The other thing that the government wants is for Google to share data related to search queries. And then the third area is the government wants the judge to ban Google from doing any kind of exclusive search agreements, the way it had with Apple and with Samsung, so that Google was the default browser and search engine on people's smartphones.
So that's the search monopoly case, which is in its final week. But can you explain big picture why the DOJ believes Google has been anti-competitive in its ad sales?
Yeah, so this was a totally separate case that was brought under the Biden administration. And this case looks at the pipeline of technology that Google controls and underpins its ability to serve ads on the web. And over the years, it acquired a number of companies, including one called DoubleClick and one called AdMeld, which allows it to control the whole transaction. And the issue there is that it's not transparent at all. It's a very opaque process, so nobody can actually see how the prices are formed and how the decisions about the cost of ads are made. It allows Google to collect what the government calls, monopoly rents. And that means that publishers are making less money, and it means that advertisers are spending more money, and those costs ultimately get passed on to consumers. So the government is alleging that this system, because it's so powerfully controlled by Google, really is operating to the detriment of consumers very broadly.
And Sara Frier, these cases are ostensibly at their core about search and ad sales, products and functions that have been Google's core offerings for years. But AI has also become a significant factor here in these cases, too. Can you talk about how this case has been looking at Google's investments in AI and how the company might have to shift its strategy in the AI space in the wake of these antitrust rulings?
That's so key here. In terms of AI, the judge in this search case says he wants to consider that in his remedy for this problem. And a couple of things have come up in the case that make Google look pretty bad. One is that they have these very expensive deals with Samsung. Google said this on the stand. They have these deals with Samsung to have their Gemini AI pre-installed on phones. Now, judges have twice ruled those kinds of exclusive pre-installed deals illegal. Google's doing it anyway for the next big market. The other thing that's really become clear in this remedies trial is how Google already has such a extreme step ahead in the AI realm because of the data it has on search. If you are a website that has your content indexed by Google search, you are opting into being used in Google's AI training. There's no way to opt out of that besides opting out of being discoverable on Google search, which is, the government argues, basically equivalent with the internet. Right.
Yeah, and if I can just jump in here, the DOJ is extremely concerned that the advent of AI could quickly allow Google to further entrench its monopoly. On the other hand, they're trying to walk a very fine line. They don't want to hold back like emerging technology either. And so, for example, they decided not to ban Google from acting as an investor in new AI enterprises. So Google, as a VC investor to help, start up new AI ventures, they're going to let that go ahead because they want Google to compete with Microsoft and Apple and the others who are, quickly developing.
Well, Sara Frier, I want to switch gears to talk about Meta. While the U.S. government has already won twice against Google, the case against Meta is still ongoing right now. We're about halfway through. Can you just help us understand what landed Meta in court and what's been litigated so far?
There is a strategy that the FTC is highlighting here from Mark Zuckerberg and his way of growing companies. They're concerned that he is seeing a competitor to his business crop up, get traction, build their network effect, and out of fear that his company will get overtaken by them or lose some users to them, he just acquires them or tries to copy them. And he's done this over and over and over. So the two acquisitions that are most in focus in this trial are the Instagram acquisition in 2012 and the WhatsApp acquisition in 2014, which was pretty much inspired by the success of the Instagram acquisition. This is complicated for the FTC because at the time, the FTC was given an opportunity to give a stamp of approval on these acquisitions, and they said, go forth. We're not going to challenge this. And so Meta's trying to say, your time to speak has passed.
Does Meta still seem like it's going to win this case? Have the dynamic shifted?
Well, Meta would say they're pretty confident, but I think that the emails that have surfaced, it is true that Zuckerberg and his leaders were constantly looking behind their shoulder to see if anyone was catching up with them in the race and constantly trying to think, how can we either crush them, buy them, build our own version of this? So the FTC has been very good at showing that. The problem is their market definition for what they consider to be Meta's monopoly. It's this kind of made-up category, personal social networking. They say that in their market definition, the social networks that Meta owns only compete with Snap, which makes Snapchat, and MeWe, which is I don't even know. I
haven't heard of that one.
And if you're a modern user of social media, that's kind of ridiculous.
Sarah Forden, what's your take?
So the case, all of these antitrust cases will ultimately turn on what the judge accepts as the market definition. And so here the FTC is arguing that Meta dominates the space for personal social networking. That's basically sharing with friends and family. So when you want to share something with friends and family, you'll go to Facebook. And the key thing is going to be also what the competitors, so Meta's saying, well, we compete with TikTok, we compete with all these other platforms. The key thing is going to be what those competitors say about who they perceive as competition. So are they competing with Facebook or are they just doing their own thing?
After the break, the political jockeying behind the scenes of these antitrust trials and what the case's outcomes could mean for social media and search. I want to talk about the politics, and I want to talk about the implications of these trials. Sara Forden, antitrust enforcement of big tech, as you both talked about, has been a rare example of continuity across both the Biden and Trump administrations. Can you explain the politics at play here?
Yeah, what we're seeing is really a sea change in antitrust enforcement that's built up over at least the last 10 plus years. And it's a shift whereby both Republicans and Democrats have started to see corporate consolidation broadly and corporate power in the tech sector specifically really grow to be very powerful. So the Democrats will look at consumer harm, whereas the Republicans started to see that these companies were so powerful, they felt they were suppressing conservative speech. And yet, even though they're coming from very different perspectives, the one thing they agree on is that these companies have gotten too big and too powerful, and it's time to, put some guardrails in place.
Sara Frier, you've been tracking Mark Zuckerberg's relationship with Trump and his lobbying efforts. Can you talk about whether they've failed?
Well, I think a lot of the big tech leaders thought of Trump as a transactional president. They have been to dinner with Trump. They've been to his inauguration. They've donated to initiatives he cares about. And so that is something that they hoped, especially Mark Zuckerberg, hoped would help them have an audience. Zuckerberg has had some luck in getting Trump and J.D. Vance to talk about what Europe's doing and saying that, Europe shouldn't be holding back our American tech companies. They have had some success in getting the administration to agree that big tech in America should be the winner of the global AI race, not those companies in China, right? But it really hasn't worked on antitrust. Google, Meta, Apple, Amazon, they're still all completely in the crosshairs on that topic. And Zuckerberg personally tried to get Trump to let Meta settle this case. And the FTC and Trump weren't willing to go for it.
Well, I want to talk about what the outcomes of these trials could mean for people who use the internet or use these social media and tech platforms. If Google had to sell off Chrome, for example, or if the Meta trial doesn't go its way, what would that mean for someone trying to make a search going on Instagram?
I think that, first of all, whatever happens is going to take a long time to happen because the resolution of the trial will come and then Google will likely appeal it and then there's going to be some back and forth. But Apple last week was forced to allow app creators in its app store to receive payments in other ways than through iPhones. And notoriously, Apple takes a large cut of the payments that go through the App Store. So this is going to hit them in terms of their revenue. So I think we might see more things like that, like little parts of their operations that seem kind of, oh, this is just the way it's always worked. I'm used to this as a consumer. Realizing that it doesn't have to be that way. Like, we don't have to have our Chrome browser following us around the entire internet and tracking everything we do on every other website to personalize our results. And with the FTC case, the most dramatic possible outcome is a spinoff of Instagram and WhatsApp from Meta. That would be like absolutely unheard of in the history of the internet, that, you know, a deal that's more than 10 years old gets undone. I just can't even imagine, because they have done so much on the back end to integrate those products. They could disentangle them,
right,
but they would fight very hard.
But I guess the government's argument in all of these cases is that it's better for consumers if there's more competition, if there's less monopoly activity. Like, that's kind of the core of these arguments, right?
Yeah, the goal of these remedies, exactly as Sara said, is to make a better experience for consumers. So imagine if you could choose from 4 or 5 browsers, and maybe there's one that really protects your data. Maybe there's one that gives you a better experience. If they're competing, then they've got more incentive to try to get your eyeballs and get you to use them. And so they're going to be more creative and more innovative.
Right. Well, we're already kind of getting a sense of how the search landscape could be changing. On Wednesday, Apple's senior vice president of services testified at the Google trial, and he said that while he believes Google should remain the default in their browser, Safari, he also said that the company is looking at revamping Safari to focus on AI-powered search engines. Sara Frier, what did you make of that? What does it say about Google's future as sort of this dominant search player?
Well, it was concerning enough to send Google stock down. The market is recognizing that if Apple thinks that there's a threat to Google's dominance, then there probably is one. You know, Apple's looking at other options, including, they said, Perplexity, OpenAI, these other chatbots that people have turned to as their gateway to information on the web. That said, we have to consider that Apple has skin in the game here. They get $20 billion a year from Google to have Google be the default on its search and on iPhones. And by framing this Google deal as part of this very competitive landscape where, it makes sense for Google to pay Apple $20 billion to be the default search on iPhones, they're preserving that $20 billion in their balance sheet.
What about the government? What are they taking away from how these trials are going so far, and how might it influence the future cases they might bring?
I mean, we've already seen these 2 landmark decisions against Google, so that's already unprecedented. We haven't seen this level of a case since they tried to break up Microsoft. What we have here potentially is a real game changer. So if the government wins, they're going to be emboldened, and they're going to, feel more confident about pursuing other complex cases. And they have a Ticketmaster case out there. They have the Apple case that's in progress. They have an Amazon case, and they're also looking at other sectors like healthcare. So there potentially could really be a wave of more antitrust enforcement. If they lose, that could probably have a chilling effect, because these cases are long, they're difficult, they're complex, they're costly. So we could really see a sea change in either direction, depending how these cases go.
Well, Sara, thank you so much for being here.
Thanks for having me.
Thanks for having us.
This is The Big Take from Bloomberg News. I'm Sara Holder. This episode was produced by Alex Tai. It was edited by Tracy Samuelson and Joshua Brewstein. It was fact-checked by Rachel Lewis-Krisky and mixed and sound designed by Alex Sugiura. Our senior producer is Naomi Shavin. Our senior editor is Elizabeth Ponso. Our deputy executive producer is Julia Weaver. Our executive producer is Nicole Beamsterboer. Sage Bauman is Bloomberg's head of podcasts. If you liked this episode, make sure to subscribe and review The Big Take wherever you listen to podcasts. It helps people find the show. Thanks for listening. We'll be back tomorrow.